time for our Law News segment sponsored by Gig in Jancola. Join with us now. We have attorney Michael Gig from the practice. Welcome to the show.
Yeah, thanks for having me.
Yes. All right. Talk about the types of law you and Chris practice.
Yeah, so I handle most of our estate planning, estate matters, real estate matters. Chris does our personal injury, workers' compensation, and Social Security.
Good stuff. And of course, when people call your office, you are the guys they're able to speak to for a consultation. You're from the area, and you've been doing this for a few years, I'd say.
Yeah, into my 10th year now. So yeah, and then Chris has been, I think he's up over 20 years now. So yeah.
A good team, I would say so. All right, and then people can submit different questions here on our show. You answer them anonymously. You see, we don't even have to say your name. But we had this coming to us, I think, last week or so. And Mike, you're going to tackle this. It says, if a husband and wife don't have a will and one becomes incapacitated or happens to pass away, does the other spouse automatically inherit assets and their debts? Okay,
so first of all, this viewer used the term incapacitated. So that has a legal, that's a legal term. So incapacitated would be the person's still alive, but they've been declared to be incapacitated, meaning they cannot make either medical decisions for themselves, financial decisions, or both. So that's why we've said in previous shows, you should have a power of attorney done while you're thinking about, while you're both mentally competent. So that kind of goes to that part of the question.
Yeah.
But if they pass away, no. This is why I tell people oftentimes, especially if you have children, especially if you have a mixed family where your husband has his own children from a previous marriage and the wife has her own children, it definitely does not go to your spouse. And depending on the situation, it could be anything from your spouse would only get half and the other kids would get the other half. It could be a situation where the spouse gets the first like $30,000 of assets and then half of everything after that. But if you have kids, whether they're your own kids or your spouse has kids, not everything goes to your spouse when you pass. That's the important thing. So if you have kids at all and you want everything to go to your spouse, then you definitely want to have a will. The debts part of this, not necessarily, well, any debts that your spouse, if they pass away, like medical bills, those are typical bills that even if you have credit cards together, you have a mortgage together, all those things, medical bills would be just in that spouse that passed away, just in their name. So those are not your debts, okay? Those are the debts specifically of your spouse that passed away. Now, typically, in general, any debts that are in the decedent's spouse's name, those creditors can only come after estate assets of that deceased spouse. So, and as we've mentioned in previous shows, someone's estate only consists of those assets that are in their name alone, okay? So if you own everything as husband and wife, there would be no estate assets, okay? And so that often comes into play here. If I know that the person, they were married for 50 years, I typically would believe that everything's in joint names, but you still have to go down through their assets and see. But no, any debts in that spouse's name that passed away would not be the surviving spouse's debts. So
I think the big takeaway is make sure everything is in both of your names.
I typically like to say that.
Yeah.
There are reasons, numerous reasons why certain people don't do that. Second marriages, you know, I've seen a lot of different examples, but if there's no good reason not to, I typically tell people that you should. It helps you in many ways, and it really helps, you know, estate planning wise, everything can just transfer automatically over to the surviving spouse without any need for an estate or anything like that.
Yeah, and we've talked many times before, and of course, it's just the way the world. Don't be surprised when people do come after you just to scare you, ask you to pay up, but it doesn't necessarily mean you have to.
And that's the thing, when a surviving spouse, when they come in and they see all these debts, they don't look at the fine print where they will say, we are only looking for this debt to be paid by assets of the estate of the person that passed away. Most people don't know what that means, and what I often see is the surviving spouse, especially if they've been married for 50 years, I mean, they want to do the right thing. That was their husband or wife. You know, the hospital or other, you know, they took care of them, and they feel a duty to pay it. But you know, so some people just want to do the right thing, but they don't know that the fine language in those letters they get.
Yeah, it is a bit scary, and a lot of different complexities, which is why it's just best to talk to a trusted attorney.
Yep.
And if people want to reach out to your office, they can do that?
Yeah, 946-1606 to call our office, or through our website at gig-law.com.
All right. Mike, thanks so much.
Thank you.